Welcome to another episode of Taxplaining. Ashley and I are really excited to have Jonathan Wilson join us today to discuss the Corporate Transparency Act, which has been the center of a legal whirlwind in recent weeks. Multiple court decisions now have sent shockwaves through the landscape, leaving all of us on the edge of our seats as to the fate of the CTA. So let's not keep people waiting. Jonathan, welcome. Please tell us about yourself, what you do, and what is going on with the CTA today.
Absolutely. And thank you, Mary and Ashley, for having me. I think one of the most important words in your last sentence is the word today, because today we're recording this thing and it is December the 19th. And that's important because we never know what might happen next. I'm a corporate lawyer. I've been in practice for about 33 years here with a law firm in Atlanta called Taylor English Duma. And I'm also the co-founder and CEO of the FinCEN Report Company, which is a commercial service provider that helps reporting companies file their BOI reports. As you mentioned in your intro, Mary, it seems like every day I wake up and I have to get messaging out to all of our partners and customers at FinCEN Report because something has happened overnight. So to set the stage, there are several lawsuits out there challenging the constitutionality of the Corporate Transparency Act. One of those was called Texas Top Cop Shop, which is really hard to say 5 times fast. And that case was filed in the federal district court in the Eastern District of Texas. That court granted plaintiffs' motion for a preliminary injunction and entered an injunction that enjoins the enforcement of the Corporate Transparency Act and its BOI report filing obligations. That order took effect around December the 3rd. Since that time, the Attorney General and the Secretary of the Treasury asked the district court to modify its injunction so that it would only apply to the plaintiffs in the case. The district court refused that motion. They then filed a motion before the Fifth Circuit Court of Appeals alongside their appeal, asking for an emergency motion to stay or modify the district court's preliminary injunction. In an interesting turn of events, the motion that the Attorney General filed asked for briefing on a schedule that would have finalized everything on December the 27th. In a letter order late last Friday night, the Fifth Circuit said, no, we want your briefing faster than that. And they ordered the plaintiffs to file their responsive motion Tuesday of this week. And then the rebuttal to that is due at noon Central Time today, Thursday the 19th. I think that the timing of that suggests that the Fifth Circuit wants to get a ruling out as soon as possible, perhaps even before next week's holiday week. You can imagine judges and their clerks wanting to clear their desks so they don't have to come back during Christmas week on Monday, December the 23rd. So I would not be shocked if we had a ruling from the Fifth Circuit sometime on Friday, December the 20th. And that's where we're at.
That is really interesting. And I'm also interested in what you think about the timing, just the fact that it took so long to get this kind of attention, because as you noted, there have been a lot of other suits filed around the country and it's the last minute, right? This is pushing it for the deadline.
Yeah, the timing has been inconvenient for all the small businesses that need to file. And FinCEN estimates that 32 million or more ought to file before the end of the year. I'm not really sure how we would have done the timing any better. FinCEN, I think, can be fairly criticized for not having gotten their regulations done when they were supposed to. Remember, the statute required that the regulations be finalized within 1 year of the date of enactment. That didn't happen. They were about a year and a half late. It's not terribly helpful that these courts are issuing preliminary injunctions so late in the process. I kind of feel that some judges might want to achieve a particular outcome with the timing of their decisions. So that's always a possibility. And then we have to layer on top of that all the action in Congress this week, which, as you know, again, today is Thursday the 19th, about 72 hours ago, the Speaker of the House drafted a continuing resolution, as Congress always does, to extend the budget. It was a 1,500-page bill, and there was a paragraph that would have changed the January 1, 2025 deadline to be January 1, 2026. Within the next 24 hours, President-elect Trump, Elon Musk, Vivek Ramaswamy all said, no, this continuing resolution is awful. We need to go back to the drawing board and start over again. And as of this moment, the continuing resolution is dead. Does Congress come back and try to do a new skinny continuing resolution that extends the budget, maybe does something with the debt ceiling, but omits all of the policy aspects and omits an extension of the January deadline? who can say?
So, speaking of the new administration, how do you think the new administration could fix the CTA, or what do you think is in the forecast there?
Well, this becomes quite a dramatic saga if you think about it, because the Corporate Transparency Act was originally vetoed by President Trump in his first administration. Congress then overrode it in one of these end-of-year budget-busting continuing resolutions. That's how the Corporate Transparency Act came into existence. And so now, 4 years later, here we are again. Presumably, Donald Trump and a lot of Republicans in Congress are instinctively hostile to business regulation. And I certainly understand that. I think I'm pretty sympathetic to that as a business lawyer myself. Now, it just so happens, as it relates to the CTA, I think that there's a very good reason for this to become law. And it all relates to the ability of the federal government to rein in money laundering, which is the lifeblood of organized crime, human trafficking, and terrorist financing. We need to know who are the beneficial owners of these many millions of anonymous corporations. So I asked myself, what could the new administration do to take the Corporate Transparency Act without asking Congress to rule on it, and just by regulatory fiat, having the new director of FinCEN make a change to the regulations? And I came up with a plan that I call Making Transparency Great Again. In my approach, the new administration would do three things. Number one, eliminate the requirement that beneficial owners provide an image of their driver's license or passport. That administrative act of photocopying a driver's license or passport and uploading it in the BOI report filing process doesn't add anything to FinCEN's database. It doesn't aid in law enforcement's ability to know who the beneficial owners are, but it is a pain in the neck, especially for older computer users that don't know how to upload their driver's license. Number two, one of the most challenging aspects of the Corporate Transparency Act is the requirement that the reporting company amend its report within 30 calendar days after any change in previously reported data, the 30-day amendment rule. It's really difficult to administer, and it's utterly impractical. We don't have any other laws in which corporations have to report data as it happens within 30 days. Let's change that, because that's not part of the statute either. That was part of the regulation. Let's change that regulation to require a quarterly update. If nothing has changed since your last report, you don't file anything. But if something has changed, you have one calendar quarter in which to file an update to reflect that change. Businesses are already accustomed to quarterly filing, and it would be very easy for businesses to simply add to their quarterly checklist, file update to BOI report, and this would become just another new habit that we would all have to have.
At that point, I have a kind of a selfish question, but I
Sure.
think it will resonate with a lot of small business owners and operators of various industries. Being from a farm family, this has been a topic my dad has brought up to me recently, wondering if he needs to file a report.
No, that's a fair question. The Corporate Transparency Act is intended to build this database of the beneficial owners of corporations and LLCs. If a particular farmer owns a piece of land in his personal capacity, and there is no corporation or LLC, this law doesn't apply to that person. He doesn't have to file anything. Now, if the farmer has an LLC that owns the farm, then that LLC, like any other LLC, would need to file its BOI report unless it were exempt. But the idea is to build this database of beneficial owners so that when the police roll up on the building and they're searching for the bad guys, in all the TV procedurals, you always have Penelope Garcia there clicking on the computer saying, oh, this building is owned by this maze of shell corporations. We don't really know who owns it. It's supposed to solve that problem. That's what Congress intended to do. That's why I think there is a value in the CTA.
I mean, it's an entity created by sort of the trigger is filing a document with the state or analogous.
That's what I thought. So I'm glad to hear my initial interpretation was correct.
Let me point out another resource that people can always use. At FinCENreport.com, we have an AI-powered answer bot. You can find it at FinCENreport.com. We named our guy Hal. And you can ask Hal any question you want about the Corporate Transparency Act. I'm monitoring all the questions and answers to make sure I don't see anything go seriously wrong. And so far, Hal is getting all the answers right.
That's great.
So I was saying that there was a third thing that I would encourage the new administration to do. In addition to getting rid of the driver's license images and in addition to getting rid of the 30-day amendment rule, and that would be to change the definition of beneficial owner. Under the regulations today, an individual is a beneficial owner if they own 25% or more of the reporting company, or if they exercise substantial control. And the definition of substantial control is about a page long, and it has 4 parts. And the fourth of those parts is that a person is a beneficial owner if they have any other form of substantial control. In other words, it's circular. The administration with the stroke of a pen could change that regulation and change the definition of substantial control so that it was limited to persons who are either on the board of directors of the company, who are senior officers of the company, or who have the power to veto or control the outcome of any major decision on the part of the reporting company. If you simply made that change along with the other 2, you would have a much simpler and much easier to apply Corporate Transparency Act. Most businesses would no longer need the help of a lawyer or accountant in order to figure out how to file the form. The form could be filed on a quarterly basis alongside of quarterly tax filings. And I think we would have a valuable tool to fight money laundering that would be much less burdensome for business.
I was wondering, and I think, obviously this is not a tax provision, but it's top of mind for tax professionals and has been since it was put in place because we are in a position to help our clients report and get in compliance and stay in compliance with this. I know in the beginning, there was a big debate over whether CPAs assisting their clients with these filings, if they were engaging in the unauthorized practice of law. And I know there's been some updates there and the position has sort of evolved over time. So I'm wondering where we are now with that and what that looks like for tax professionals, because I think there are those out there who are still wondering what their obligations are and what they can and can't do.
And I don't know that there is a great answer to that question because the unauthorized practice of law is a state level criminal offense, and the rule is different in all 50 states. I think most states have completely stayed out of the mix, so we don't have any guidance there. I think that most of the major insurers for the accounting firms have issued letters that suggest that CPAs will be covered by their policies if they're advising clients on how to fill out and file their forms. I think there have been some advisory opinions. I think in the state of New Jersey might be one.
New Jersey, yeah.
Yeah, that have suggested that ordinary run-of-the-mill, how do I file this form type questions can be answered by CPAs with some caution about CPAs going out and issuing legal opinions. That's about the best answer we have. My understanding is that there are many CPA firms that are regularly advising clients on this.
I know Mary loves a good UPL discussion.
I love it. Yeah.
Who doesn't?
And that's what I was going for. So,
I was trying to bait you, but it is an important point in all seriousness. I think because keeping up with the changes in the tax law alone is a lot for any tax practitioner. And then you throw in this entire new law, new procedure, new process, and you're having to notify clients and all of that. I think it's important to get an update from someone like you who's an expert and you're really embedded in this CTA space.
Yeah.
I appreciate that. Yeah.
I do have maybe just another question or two, going back kind of to the drama in the courtrooms right now. And I know you had written an interesting piece about this, and listeners, I would encourage you to look for Jonathan on LinkedIn and elsewhere. What are your thoughts, if you don't mind sharing briefly, about just sort of generally these national injunctions and the trend there and how it might play out here? I know this is speculative, but kind of based on what you wrote in an interesting recent case and what you thought there.
Sure. And that case, I did a little write-up on it on LinkedIn. If you read the brief that the Attorney General filed in the Fifth Circuit in the motion to stay the injunction, the Attorney General cites a Supreme Court case called Labrador versus Poe. And it was a case involving an Idaho state law that prohibited doctors from prescribing certain medicines and medical procedures to teenagers in gender reassignment or transitioning circumstances. The plaintiffs in that case were a child and the child's parents who sued for an injunction to prevent that law from prohibiting them from getting medical care. The district court in the Idaho case enjoined the law both as to those plaintiffs and as to everybody else, saying that the law was probably unconstitutional. The Ninth Circuit Court of Appeals affirmed, and when it went up to the Supreme Court reversed, modified the stay, and sent it back. After the Supreme Court was done with it, the injunction remained in place as to the child and the parents who had asked for the injunction, so they could continue to get their medical treatment, notwithstanding this law. But anybody else was still subject to the law while the challenge was litigated. And the reasoning behind this was that, in Justice Gorsuch's view, there were far too many of these nationwide injunctions. They were mucking up the court system. They were creating too many emergency situations where one federal judge could basically pull the cord and put the brakes on a law that would affect everyone in the United States based on the circumstances put forward by one plaintiff. The ruling of the Supreme Court in this Labrador versus Poe case, April 2024, was that district courts ought to only issue injunctions based on the facts of the plaintiffs before them in their particular case. So in the Idaho case, the Supreme Court said proper to have an injunction for this child and the child's parents, but no need to issue an injunction for everybody else. This Labrador versus Poe case is only a few months old, so if I'm applying that to the case in the Texas Top Cop Shop case, I think the Supreme Court would say that judge should have issued an injunction for the plaintiffs who were there in that particular case. But that district court should not have issued a nationwide injunction that affects the other 32 million companies that have been preparing to file. Now, whether the Fifth Circuit will follow that reasoning or not, I don't know. But that was clearly at the heart of the Attorney General's motion, and I'm looking forward to seeing what the Fifth Circuit does with that argument.
Yeah, I'm inclined to agree with you if I were to guess what the Fifth Circuit is going to do. But I still kind of see a distinction there. We've got this pre-existing split already in the nation. We didn't have that in Labrador, right? And it leads me to my next question. Where do you think the CTA is most vulnerable in the process right now, in the courts? What argument was the plaintiff's strongest, in your opinion?
Great question. So the plaintiffs in the Texas Top Cop Shop case made a bunch of different arguments, the same arguments that all the different challenges have made. They're based on First, Fourth, and Fifth Amendment arguments, and then this argument under the Commerce Clause. Unfortunately, I'm not terribly persuaded by any of them. In particular, Congress has long used the Commerce Clause as an area in which it can legislate. It has issued laws that criminalize the possession of marijuana, even when it is not being used or sold in interstate commerce. We all learned in law school, anything that is done, even if it's done solely within the confines of a single state, if it has the cumulative effect of having an impact on interstate commerce, the Supreme Court has held that that is a proper exercise of Congress's power. So in the context of the CTA, Congress reasoned that the formation of LLCs and corporations, even when they were not engaged in interstate commerce, had the effect of impacting interstate commerce because it was used by money launderers when they engage in money laundering. And it was for that reason that the CTA requires LLCs and corporations to file beneficial ownership reports. The plaintiff's argument is that the mere act of creating a corporation does not constitute an act in interstate commerce. And I think that that misses the point. And the larger point is that the Commerce Clause, as we all learned it in law school and has been applied for about 100 years, is that an activity that has a cumulative effect of impacting interstate commerce is within the scope of Congress for purposes of the Interstate Commerce Clause. And that is why I believe we've had 3 different district judges basically reach that decision in substantive rulings on the Corporate Transparency Act. We got a different result in Alabama. The Alabama case, of course, is still up on appeal in the 11th Circuit. We got the different result here in Texas. That decision is now on appeal in the 5th Circuit. So we'll have to let those appellate courts reach their conclusions. But Justice Jonathan, if I had a vote, I would say that the CTA was within the scope of the Commerce Clause.
Well, thank you for answering that. It's also interesting. Ashley, did you have any more questions?
I don't think I do. I think this has been very informative and it's going to be very interesting to see how this plays out in the coming hours, days, and weeks. So,
yeah, absolutely. This has been fascinating, so helpful. I'm sure our listeners have learned a ton. So we're really grateful that you came and shared this with us today, Jonathan.
Well, thank you both for the opportunity. I've enjoyed speaking with you both.
That's a wrap for this episode of Taxplaining. There will be a lot more updates coming through. This is a lot of drama right now. I would encourage you to follow Jonathan Wilson on LinkedIn and look him up and his company at fenceandreport.com.